Welcome to today's deep dive crafted just for you. Imagine you're doing your taxes and you're using a calculator that just completely in secret decides to add some random number to your final bill.
Right, you'd be furious. I mean, you expect a machine like that to give you a precise mathematical truth.
Exactly. But what if that calculator is actually a breathalyzer deciding whether you go to prison? Because in March 2026, the California Department of Justice dropped this massive bombshell, admitting to a 10-year systemic failure in the state's DUI breath testing.
Yeah, it is wild. And we really need to get right into the hardware at the center of this, which is the AlcoSensor VXL. These devices are literally everywhere in California.
And they rely on electrochemical fuel cells, right? Like, how do those actually work?
Well, they do rely on those cells. So when you blow into the tube, the alcohol oxidizes at a platinum electrode, and that produces an electrical current. The software reads the strength of that current to calculate your BAC.
But the chemistry itself isn't really the issue here. It's the interpretation. The DOJ disclosure highlights this proprietary software glitch, where the software misinterprets the electrical current right at the plateau of the breath sample.
Right. Instead of reading the steady state, it just spikes. It artificially inflates the BAC reading.
Which is terrifying. And on top of that digital flaw, the physical hardware has its own problems. Like, the AlcoSensor V has a known mechanical defect with condensation building up inside the sampling tube.
Right, which traps residual alcohol from previous tests.
That is like brewing a fresh pot of coffee through yesterday's used filter. I mean, doesn't that basically guarantee tainted results for an innocent driver taking the test next?
It completely compromises the scientific integrity. And when hardware is that fragile, the only safety net left is the human operator following the manual perfectly.
Which evidently was not happening either, because California has Title 17, which is this strict rule book requiring a 15-minute continuous observation window before a test.
Right, and that window is crucial to prevent mouth alcohol. Like if you burp or if you suffer from GERD or acid reflux, raw alcohol vapor from your stomach enters your mouth.
And the machine operates on a rigid 2100 to 1 ratio of breath alcohol to blood alcohol, so a microscopic amount of mouth alcohol just shatters that math.
Exactly. And state audits showed officers were routinely skipping that 15-minute window altogether.
Plus, they're calibrating the machines using expired or leaking dry gas standards. And just to be clear for you listening, a dry gas standard is the control substance.
Right. It's a canister of gas with a known precise alcohol concentration used to set the baseline.
So if that canister is leaking or expired, the machine's baseline is effectively garbage. Everything it measures after that is wrong.
It's the equivalent of using a warped ruler to build a house. You just can't do it.
So how can the state possibly defend this? I mean, to use scientific evidence, you have to meet the Kelly-Frye standard of reliability. Are judges just throwing these cases out?
Well, it's creating massive chaos in the courts right now. Prosecutors are trying to argue substantial compliance, claiming the errors weren't severe enough to alter the verdict.
But defense attorneys must be hammering that Kelly-Frye standard.
Oh, absolutely. They're pointing out that you cannot have substantial compliance with a broken baseline. So we're seeing judges suppress the breath results entirely, which forces the state to rely solely on subjective field sobriety tests.
And this whole historical sloppiness is colliding with a very harsh new reality in 2026, because Assembly Bill 366 just mandated ignition interlock devices for all first-time offenders.
Right. Those are the IIDs where you literally have to blow into your car to start it. And those use the exact same flawed electrochemical fuel cell technology.
Wow. And the stakes are exponentially higher now because Assembly Bill 1546 elevates a third DUI within 10 years to a potential felony.
Exactly. So a faulty reading from a poorly calibrated machine 8 years ago could act as the strike that sends you to state prison today.
That is wild. And let's add biological reality to that mix. The data shows a keto diet makes your body produce acetone, and these fuel cells can falsely register that acetone as alcohol.
Yeah, and even a slight fever, like just a 1 degree Celsius increase in body temperature, artificially inflates a BAC reading by 6%. The machine doesn't know you have a fever.
It just registers an electrical current, which creates the ultimate implied consent trap for you as a driver. If you get pulled over, refusing a test automatically suspends your license.
But taking the test on a low-carb diet or with a mild fever could trigger those new felony escalation rules. It's a nightmare.
The reliance on a single BAC number from a proprietary black box is just fundamentally broken. We clearly need transparent data and independent laboratory oversight.
Definitely. It has to be completely separate from law enforcement pressures.
We really cannot keep trusting the broken calculator. But that leaves you with a really provocative question to ponder.
What's that?
If California decides to abandon breathalyzers entirely and shift to blood testing just to guarantee scientific accuracy, how will the logistical nightmare of processing millions of blood vials impact a defendant's constitutional right to a speedy trial? Something to think about until next time.